It takes a class act to cover a topic regarding class actions. And we have that in our next presenter, Scott O'Connell of Nixon Peabody. Scott is the co-chair of the firm's litigation department. He is a member of the firm's management committee. He's a trial lawyer known for his perseverance, strategic thinking, and value-driven service for clients. Scott focuses on class action and aggregate litigation, as well as corporate governance and control contests. He currently represents financial services and healthcare companies in high-exposure disputes with associated significant reputational harm in parallel civil, criminal, and regulatory proceedings. Here to talk about a topic that we really need more of, class action reform, please welcome Scott O'Connell.
Thank you, John. Morning, thank you. This body's built for winter, but even I'm cold. I think I can see my breath. Class action, something that affects all of you in one way or another. Your clients hate them, they're high exposure, they cause reputational harm, they get to board level because of the amount of exposure involved, and when you settle these cases, they cause all kinds of disruption for your clients. It's usually attacking a practice or a business method that is disruptive, and so they are a scourge and they are a problem. I spend most of my time in this area, and I must say that the past 6 years has been transformative as to the way the practice has evolved. The Supreme Court, over the past 4 terms, has been very active in taking on all manner of class action cases. And we could spend the whole day diving into the areas in which they've made some fundamental changes. But it is true, the practice today is radically different than it was 6 years ago. So I'm hopefully going to highlight for you, on the basis of 4 of the cases decided since 2011, a couple practical pointers that I think carry through to many of the class actions that are probably sitting on your desk as we sit here today to speak about the changes that are applicable. I want to highlight some of the significant process and standard changes that have been implemented by the Supreme Court, enunciated by the Supreme Court, and implemented by the district courts. And I truly believe we are in a new era as to how district courts are going to scrutinize claims of a class nature. And I think the plaintiff's bar laments these 4 decisions because it changes radically their calculus. When do they have a valid claim that presents the type of risk that I was discussing at the beginning of this presentation, that would get a board-level attention, that would have extortionate qualities that requires you and your clients to settle early? That world has changed in material ways. So we're going to talk very briefly about some of the takeaways from Dukes, Comcast, Concepcion, and American Express. The first 2 cases on this list deal with the standards that must be applied in scrutinizing these cases at class certification. The last 2 cases is on this parallel track of allowing those of you with customer-facing products and services that are governed by contract, the ways in which you can contract out of aggregate litigation. Supreme Court has made quite clear, and we'll talk about the exceptions to this, but quite clear that valid agreements to arbitrate on a sole basis and waiving aggregate litigation or representative status are valid. Now, there's one gigantic footnote before Larry Polk jumps up and reminds everybody FINRA is a different world. And we'll talk a little bit about the nuances to what's happening in FINRA and the ways in which Schwab tried to pull Concepcion and the Italian Colors case into their world and the current state of play there. But for the rest of you who are not in an SRO, FINRA specifically, these are important developments, and it highlights a strategic call that you and your clients need to make. What do you want to do? Do you want to try and contract out of the aggregate litigation, go to the route of arbitrations, individual, and many of them? And some companies have decided that has not been the best strategy. Be careful what you wish for. You may get out of aggregate litigation, but you may get a plethora of arbitrations. And the question is that what your clients really do want? I would say for many, it has had a chilling effect in the filing in the first instance, but some have had to deal with the back-end consequence of customer arbitrations that have multiplied. But given the changes in court, maybe you take your chance and make your best case to beat certification in the district court. So, quick reminder, class actions requires Numerosity, commonality, typicality, and you have to have a representative plaintiff in order, in the first instance, to get in the door with your class claim. Now, again, the law around the country on these four issues has been well developed. What I want to talk about is what does the district court have to do because of these cases to look at these provisions. Walmart introduced this notion that existed in the law before it was held by the Supreme Court to be the law of the land, but is now getting applied with some rigor. A rigorous standard to look at numerosity, commonality, typicality, and adequate representation. Now, as a practical matter, that means the district court has to do an inquiry that is much more extensive than a motion to dismiss. Motion to dismiss, you're stuck with the four corners of the pleading for the most part, or things that are referenced therein. Class certification now requires the judge to climb behind those allegations and make sure that every one of these representative standards are looked at with rigorous review. And it also gives you as the defendant the opportunity to bring forward all the ways in which this rigorous standard is not met. A huge hurdle as a practical matter that plaintiffs have had to overcome with this change. The other point that I'll make is with regard to Rule 23B, which is the opt-out class that we're all familiar with. That's the vast majority of claims are brought under that provision. As a result, when you look at that standard, I lost my train of thought. In addition to the four provisions I referenced before, 23B adds this additional requirement of predominance. In addition to everything else we were talking about, the common issues of law and fact must predominate, and the class vehicle must be the superior way to deal with the claims as a whole. Now, that sounds pretty straightforward, and it doesn't sound like what I'm discussing foists a change. But before the case I'm going to be talking about, the Comcast decision, the circuit courts were all over the place, with the Ninth Circuit being an outlier on the notion of what predominance meant. And there was a bifurcation line of cases that said, well, you can have predominance on some of the issues at the front end of the case, but if there were individual damage inquiries, that was not enough to defeat class certification. And therein lied a problem. Beating back these things at class certification was difficult. Judges were accepting the notion that there could be certain aspects of predominance, and that was sufficient to use the class vehicle as opposed to an individual cause of action. Well, let's bring forward the 2013 case of Comcast. Underneath the analysis of Dukes, we got this rigorous standard concept. In looking at the predominant standard of 23B, the Supreme Court said in Comcast, it is exactly the same thing. Predominance requires the type of rigorous analysis that we said was essential in our Dukes decision. Remember, Dukes was 1.5 million women who brought wage and discrimination claims against Walmart. A very large class. And it was ultimately decertified because the commonality and typicality did not survive the rigorous standard. Now we get to predominance. This is an antitrust case, and the issue is whether or not there was a common damage claim that applied, or a common damage calculation method that would apply to all members of the class in the case. And the Supreme Court said, no, there's not. Predominance requires you need to bring forward a common allegation, a common method, common way of determining damages for all the members of the class. If you can't do that, there is no predominance, and you can't have certification. What's really interesting is that the court said, with regard to 23B3, the rigorous standard with regard to predominance is even more important. So what does this mean as a practical matter for the lawyers who are handling your class actions right now? The battle, as it always has been, but more so now, is at class certification. And these tools are potent. To the extent district courts were willing to, give the gestalt of this kind of feels like there's some overriding principles, maybe there is some commonality, maybe it does feel like there are some ways in which many plaintiffs can hang together and this can be decided. Now the rigorous standard raises that bar. If you can't demonstrate that the class meets that rigorous standard, there's no class certification. So the battle happens there, and the battle happens with information that you collect with your clients about the ways in which predominance is not applicable, and it happens at the front of the case. So when you get a putative class action landing on your desk, the first instruction to your in-house client contacts and your outside lawyers is to develop the basis upon which we're going to beat back predominance and the other 4 requirements of 23A. Okay, so those are 2 procedural ways in which the Supreme Court has given the mandate to the federal courts to do something differently. Some were doing this already, but it was inconsistently applied. And since 2011, since Dukes was issued, I can represent, and a lot of this is in the materials that we've provided to you, it has really cascaded through the district and circuit courts. This rigorous standard has life and teeth to it. That's one area in which you can beat back these things. As I said at the setup of this presentation, another area that has been developing over the past half dozen years is the way in which consumer-facing companies can contract out of this type of aggregate litigation. The Concepcion case was the seminal case that the Supreme Court decided and indicated, I'm sorry, I think we're missing one. Can you go back one? There we go, thank you. Concepcion made clear that the FAA, the Federal Arbitration Act, is the supreme law of the land. And when states try to treat arbitration differently than another court proceeding and discriminate against it and make it harder by issue of contract with issues that are peculiar to arbitration, it is supplanted by the federal law. So bottom line is, unless there are issues of unconscionability under state law, there's some fundamental formation issue with this contract. There's no meeting of the minds. There's a level of adhesion that state law would find objectionable, or any of the types of things that go to the formation of the contract. Absent that, you can contract your way out of these claims. Now, how did AT&T do it? They had a very consumer-friendly arbitration provision that paid additional costs to the plaintiff for the right to get this into the forum. Other companies have given cooling off periods. In other words, once you sign the contract, you have 30, 60, 90 days to send a note to the company that you want to opt out of this. No questions asked, no penalty of the benefits of your bargain. And they have been upheld as not creating a contract of adhesion that is unconscionable under various state laws. So, going this direction may be a viable alternative if you're not a FINRA, SRO-regulated entity, and you're a consumer-facing bank that has a product, you can contract out of it. But you need to pay attention to the state law of unconscionability as to whether or not it's a problem. That concept has been underscored half a dozen times by summary decisions of the Supreme Court over the past 3 years, but this past term, there was a developing challenge to the ability to contract out of these cases, and that had to do with whether there was an argument that by choosing arbitration, you could not vindicate another right provided by state or federal law. The state claims vindication of right argument is dead. American Express decides quite clearly and says what I think we all understand as a matter of preemption: state law can't trump federal law unless Congress creates a scheme where that is to be the case. But with regard to this issue, there can be no argument that some kind of state statute, an unfair and deceptive trade practice claim under state law, somehow can be the basis in which you undermine an agreement, a valid and enforceable agreement to arbitrate. So that's decided. And with regard to the antitrust issue, which is another federal right and remedy, the Supreme Court said, even though it's very expensive for an individual to go into arbitration in an antitrust circumstance, they upheld the validity of the requirement that it be arbitrated. And so the argument that it would be too costly and where there was some dovetailing with the unconscionability concepts I was just describing, the Supreme Court said, no, it's not enough. A valid agreement to arbitrate will be enforced. So you got this rigorous scrutiny standard, and you've got this ability to contract out. And so as a practical matter, what does that mean for you and your clients? As I've been saying, as I've talked about the Concepcion case and American Express, people needed to stop and look at whether arbitration was a viable option. But as you digest Comcast and Dukes, you have to stop and say, is federal court really a terrible place to have a class action decided? The rigorous standard makes the patchwork and the mosaic of law that was being applied in district courts and circuits around the country much more uniform. And we all know that your clients demand, in its analysis, as much predictability as possible. And I guess the thesis from this conversation I'm having with you is that the federal court has become as predictable on this issue as it's been in my adult lifetime since I've been practicing law for 25 years. So you can take that back to your clients and say, look, this is not a terrible place to be. We may take our shot. If we've got the right people on the front line who are going to aggregate the issues to beat back on predominance, commonality, typicality, and the rest, we've got a good shot, and maybe we want to be there. And maybe we want to be there because guess what? We have appellate review, which we don't have in arbitration. We have the ability to make sure that anything that untoward happens at the district court level can get reviewed, and that doesn't happen once you push this into the private context. So, real question as a matter of strategy is, do we want to stay with Concepcion and American Express and do arbitration because we do recognize that the plaintiff's bar has responded with a multiplicity of arbitrations, taking the invitation to do individual claims? Is that in the best interests of your line of business, or do you want to take your chances in a federal court? I would submit that's an active debate. If you haven't had it with your line of business, with the contracts that govern your relationships with customers recently, it's time to come back to that and look at the materials that we've provided, which goes into much more detail the ways in which I believe the table has been set for friendly disposition of certainly spurious class action allegations for the benefit of our clients. I did say that there was one large asterisk which applies to FINRA. There was a battle joined over the past 2 years by Schwab. And just to set the table a little bit, FINRA rules prohibit this type of Concepcion, Amex, Italian Colors type of approach of disclaiming aggregate liability. You can't contract out of it. After these Supreme Court cases came down and the predominance of federal law, the FAA, was established, or reaffirmed, I should say, by the Supreme Court, Schwab took a run at this and included the waiver within its customer agreements in violation of the FINRA rules. And ultimately, at the first level, it passed muster, and the arbitration panel said, yeah, we're compelled under our Concepcion to breathe life into this FAA argument. When it was brought to the Board of Governors, however, they said, no, we are an SRO, we set our own rules, we have the right to set our own rules, and it's inappropriate for any member, any sanctioned broker-dealer to transcend that. So as I understand it, that issue has been pulled off the table, it's out of the agreements of Schwab, but that's an open issue that someone is going to pick up and run with at some point in time. I think the table is set, and of course the dynamic is, does any entity really want to take on and fight that issue with their regulator? But I would say that the law is primed for that debate, and given the way the Supreme Court has reaffirmed the validity of the Federal Arbitration Act over much else, including antitrust laws, there's a good shot that that could get challenged in the next half dozen years. So that's it on class actions. That's the transformation that I've been seeing. I hope that's helpful. I hope you can take some of that back, work with your outside lawyers, and make a difference on the things you're handling right now. Thanks for your attention.